Good afternoon, good morning, everyone. Welcome to Liticast. We are broadcasting live on litify.com, on our YouTube channel, on LinkedIn, on Facebook Live. Thank you all for joining us. Today we've got a very special episode. Supreme Court Justice Deno Himonas joining us from Utah, as well as John Lund. These are the co-chairs of the Utah Implementation Task Force on Regulatory Reform. And I am John Robinson, Dove Slansky from Litify, joining you as well. Thank you, gentlemen, all for joining us today.
Our pleasure.
Great to be here.
Those of you who are watching us live, please post your questions, post your comments on whatever channel you're watching us on. We intend to get to all of your questions and comments as much as possible today. Shortly, we'll also be joined by Carson Pearson of Pearson Butler to get his commentary as well on the regulatory reform. Also want to thank David Clark from the Utah Bar Association who helped facilitate this. So thank you, David, if you're watching us live. We are going to talk a lot about this regulatory reform today and what it actually means for the state of Utah, potentially what it means nationwide. I think it's pertinent to start first with describing what the task force has been attempting to do here and what was the driving force behind starting this initiative.
John, lead off.
You want me to lead off? Well, the origins of this date back a couple of years, but I think there's a broader based concern in our jurisdiction for access to justice, certainly something the courts have had a concern about. We formed this task force, must be on the order of 2 years ago now, as an outgrowth of really seeing that a key element to increasing access to justice was to look at reforming the regulatory environment and creating room for more innovative approaches than our current regulatory system allows. So that's really unfolded through a great group of people, national experts, local authorities, we all work together to kind of look at how to do this, and submit a report to the court in August of last year that recommended easing restrictions on lawyers, easing restrictions on fee sharing arrangements, on advertising, but also, and I think this is the piece that we're really kind of here to talk about today, creating a sandbox where experimentation can happen in a controlled environment, which would involve people who aren't lawyers or who are working with lawyers in some new business structure to provide some sort of discrete and innovative legal service that really meets the unmet need. Is that answering the question? I'm not sure that answers what drives it. Maybe that's something for you, Justice Himonas.
From my perspective, what's driven all of this is an enormous access to justice gap, which John referenced, and the court's dedication over the past 5 years through a variety of programs to try to tackle that, really change the kind of the legal ecosystem. Those changes included the licensed paralegal program, online dispute resolution, form reform, kind of a long list of things. And this is the latest, I should say, and the biggest step that the court has taken to really bridge the gap.
Yeah, and I think the rationale behind it is tremendous, right? This is not being done for business purposes or anything like that. It's simply being done because if you ease some of these long-standing restrictions, the thought and what we've seen from the UK in some limited numbers, or Australia, is that it provides greater access to justice.
Yeah, I think if we're being completely open about this, right, completely candid about this, a lot of the things that ended up in the rules of professional responsibility or conduct are really protectionistic measures. And if you trace them back, 5.4's prohibition against outside ownership is an excellent one. The Arizona report, Arizona is pursuing a similar model, really did a nice job of that. And if you go back to the history, you can see that. I mean, it's just explicit that was the case. And what John and I and others are about are trying to identify those, remove them, and really kind of open up the market in a way that we think will sustain efforts that are aimed at access to justice, at improving access to justice. What we found is we can't volunteer ourselves away. I mean, we as lawyers, John, everybody, we donate incredible amounts of time. I mean, billions of dollars worth of time over decades to try to help, and that's important. I'm not saying that's something we have to keep up, but it's not worked.
Well, and I would add that there's definitely a protectionist element to some of the rules, but we're sort of the victim of our own chains as a legal profession. We by virtue of those constraints on how we advertise or constraints on how we structure legal business have really forced most law business into a very uncreative, constraining sort of a practice, which is it's got to be the capital of the people who own the business. Only people who can own the business are the lawyers. No one else can have any sort of a management or control position. And if you compare that to other industries, we're really stultifying the way things could happen in the legal business for lawyers as well as other people. I mean, let's face it, there's a lot of concern that this is a threat to the legal industry, and I think we should talk about that. But as much as it's a threat, it's an opportunity for people already in the practice of law to do it in new and different ways that they currently can't.
Well said, John.
Yeah, this is a way of removing some of the shackles that we've perhaps placed upon ourselves, right? The community is extremely insular, and in many ways it's a good thing, right? In many ways it's a good thing where it's very close-knit, people share information, but when you lock down the doors and you keep the rest of the world out, and you try to couch it in the name of ethics, I think what's happened is that we finally reached that moment where people are saying, like, let's be honest with ourselves, that this is, and you guys are leading that charge, which is let's be candid about this, right? This is not, if we let outside ownership in, that's not going to lead to the fall of legal ethics and society in general.
Yeah, I mean, I practiced in a law firm for a long time, and we all know what the pressures are, economic pressures are practicing in a law firm. I think it's not legit to say, oh, they'll suddenly go up and my ethics are so weak that if those pressures are coming from a non-lawyer versus a lawyer, I'll crumble. And that's certainly not been the case in the UK, right? I mean, we know that there's not been an increase in disciplinary actions as a result of the move to alternative business structures. So, you're right.
So we talked about this initially, framing it in terms of access to justice and how this can help bring legal services to those who may not be reaching out and obtaining those services today. I think it's important to talk a little bit about what is happening today and how this will actually evolve that and what the future could potentially look like. There are those who are not seeking legal advice today because they can't afford it, because they don't have access to legal services financially. What does the evolution of this look like? Should this reform pass? What could the potential be for those who are seeking legal services in the future?
Can we take that one?
Sure.
I mean, I think we don't know exactly because we can't imagine what imaginations may bring about. But I would start with this. When's the last time that you heard that there was a new app for your phone to provide some sort of legal service? That doesn't happen, right? And on the one hand, we know, and we just had a great study come out in Utah about the vast portion of the population that's either not seeking legal services or not getting them when they do seek legal services. And in part, it's because there's not good, clear access. There's not good, discrete services that would, meet their one particular need without signing on for an undefined hourly rate arrangement with a law firm or with a lawyer. So what services will come into that space and meet, which is what we believe is primarily consumer needs for legal services. Well, I mean, Justice Himonas, you could share some of the people who have come and provided their ideas to us. I mean, we've had a very exciting interchange over the last couple of weeks with the type of people who may come into our sandbox.
Yeah, so there is no shortage of applicants or ideas out there. And I'm excited about that. And there are, and think of so many ways you could do the entire program, just the four of us kicking around a variety of different ways in which this opens up access. Give you just a couple of examples of things that we've talked about amongst ourselves and with others. Is there is a program that BYU developed out of their development lab to help respondents in debt collection cases and small claims, or in flesh out, not just in debt collection cases, but flesh out answers. But what if that app that they built was also capable of delivering some procedural advice at the same time, right? That's an example. Trust in estates. I mean, a lot of the wills out there are either, a lot of the population just doesn't have estate planning done, or if they do, they're inaccurate. What if you could get online and answer a series of questions, bot-driven questions, and create a document, create an estate, and then obviously through your triage to questions that are, or estates that really do need lawyers, and push them in that direction. They're just
another one that I think is an interesting piece is we concern ourselves deeply with the eviction calendar, where in a situation where 95% of the landlords have 95% of the tenants do not have legal counsel, and a lot of landlords do, and some don't. But let's back up. What about preventative law? Is there a place long before you got to an eviction calendar, when if you'd understood your lease better, you understood what you got yourself into and how you could avoid being in a situation where you were in default, you could get some kind of good legal advice about what your lease required and how to deal with it. And can somebody automate that, mass produce that, give a discrete piece of advice about the lease that would help the person avoid that? I hope so. I mean, that's the type of thing we want to create space for.
Yeah, I think the examples in some of the FAQs in the sandbox, one of them resonated to me particularly, I think, useful in rural areas, where it's like, what if a supermarket, I think you guys called it whatever, Save Mart, whatever it was, what if there was a kiosk where you can get legal advice? It sounds somewhat humorous right now, but why not? Why not have a section of the store where there are lawyers sitting there? And one of the things that's stopping now is probably public image. Lawyers don't want to be that person. Also capital. Right? They're going to have to pay the store to rent that space with no guarantee of income or anything else. But if the store was able to say, hey, well, you work for us now, essentially as a lawyer, because we own the business, and this is just a service we can now provide our customers, I think we'd see opening just, again, it's available. Even if the pricing structure stays the same, it just becomes so much more accessible rather than trekking across town to some dingy office where you already feel like you're an outsider before you ever walk in that door.
Yeah, think about, I mean, it wasn't, now we have Starbucks in stores, we have banks in stores, we have optical shops in stores. I mean, all of this a couple decades ago was, oh, no, that's, unheard of, not going to happen. I take the point. No, that last example didn't, but the other examples are really technology driven, but one of the points that I like to make is that we're not just talking about technology. We're also talking about folks who could deliver legal advice and under what principles. For example, Utah and many states for a long time has allowed real estate agents and real estate brokers to deliver legal advice with respect to REPC contracts, real estate purchase contracts. I mean, it's now the vast majority of states in the country do that, right? So this is a bridge we crossed a long time ago. But what if we went a little bit farther? We were talking offline the other day, and I mentioned, what if community first responders like social workers or librarians were able to take a class, and as long as they're not charging for it, they're providing the advice in good faith, just help people, answer some very simple questions that people have. These are people that aren't going to be asking lawyers. It's not taking any money out of anybody's pocket. And it's really helping the public, where the rubber meets the road in terms of justice.
Yeah, that's a great point where we, the conversation starts to veer into where and I think, and I've heard this from some of my friends that are lawyers, and some of them are scared, like, oh, they're taking the business away from us by allowing outside ownership in. Right now that someone else can own the business, or now that someone else can fund it, it now devalues lawyers. And I actually responded, which is, I think it actually raises their value, right? Because now, instead of, if I wanted to open up a law firm, right, the prohibitive step there is capital. Right? It costs a lot of money to start a business. That's any business, not just a law firm, but it costs a lot of money to start a business. And until now, I was limited in the fact that I had to have a partner who was also a lawyer.
Right, and that's essentially a false constraint on how the economic activity could go. And I think one of the things I say to lawyers that have that concern is that there is a day when everybody got their movies from Blockbuster. That was the distribution method. There's a day now when people get their movies and their entertainment content, obviously, through online services, Netflix, Hulu, you name it. But the underlying provider, the actor, the writer, the producer, are still out there doing what they do and doing what they love, and probably doing it in a setting, that's more conducive to their creativity than if they were trying to run their own operation. So if the distribution model for legal services changes, that does not mean that the opportunity to provide legal counsel to people is going to go away. It probably means it's going to increase.
Yeah,
that analogy is amazing, right? By simply opening it up, Blockbuster had the monopoly. Everybody went, you drove to the store and you got it, and there was a finite amount of movie, right? There was only what was on the shelf. And once it opened up, and again, there obviously other factors have to be involved, but once that opened up, now the same, like you mentioned, the same studios, actors, directors, they were able to reach a wider audience. And now more actors, more directors, more studios can also produce, because that avenue has been opened up. There's simply more money to fund the industry.
And I don't mean to bogart the conversation here, but think about what that means for the consumer. And could we do this? There's much more content available out there, and probably a lower cost and more accessible. And that's essentially the same place we'd like to provide for consumers of legal services.
Yeah, and Justice Himonas, I think you hit on it when you say a lot of this is about technology, because that provides the scale that we've been lacking, right? When we talk about how do you bring this to more people, again, that distribution model, John, right? How do you bring this to more people? The technology platforms there play a key role. And I think you tossed out a couple of examples that if someone can create for wills or estates, a bot that asks questions, and it for certain ones, that's not going to replace ones that need some complex lawyering, but for many of them or certain ones, you can produce the end result, which is someone who didn't have a will now has one. That's a net positive.
Yeah, I don't see TurboTax making CPAs go away. Hasn't happened, right? And Hunting or anything else. I mean, that's just not the way it's actually worked. Look, there is, people are trying to measure the unmet legal needs market. I don't know that we've really been able to put to monetize it, but it's enormous. It's absolutely enormous. We know, for example, this Utah study, looking at people at 200% or below of the federal poverty guideline, 83.3% of their needs are unmet. Right? A recent study across the country, 86% for the poor. And that doesn't stop once you go above it. Right? We've seen that all the way to the very top, there's a gap. I mean, I don't know I don't know, John, others, if we were involved in litigation, we really couldn't afford ourselves. Who's going to afford the $1 million and the risk? I mean, it's just inordinately expensive. And this last study out of Utah, just released last Thursday, really highlighted the problem, right? And that it's kind of financially driven. If we figure out a delivery mechanism, though, like John is talking about, that allows us to kind of profitably be able to help those people and hit that gap, great.
I want to remind our guests watching us live that we are taking questions. We are taking comments. If you have any feedback, or you'd like us to touch on any specific topics, please go ahead and use the comments on whatever channel you're watching us on right now. I do think that both of you brought up, all three of you brought up an interesting point about bringing legal up to speed with other businesses and kind of unshackling the restraints that really have prevented the legal industry from operating in somewhat of a free market economy where you have the ability to innovate. It's an interesting concept, and one that really it's taken a while to kind of catch speed nationwide. You guys are on the forefront of this. What do you think, if this winds up moving forward and passes, what do you think this means for other states? Do you think they'll follow in lockstep?
Well, no, I don't think the states are not showing themselves in any setting to be lockstep followers. All we have to do is look at the varied COVID responses around the country. But I think that there is definitely interest and movement across the country. There are some other early movers. Arizona is certainly, the next most clear example of that. We have weekly, if not daily, inquiries from various jurisdictions. And we have a lot of support, by the way, from the Institute for the Advancement of the American Legal System out of the University of Denver, as well as the National Center for State Courts, to really provide a coordinated platform for communications about these things across the country. There are definitely pockets, I shouldn't say pockets, areas where there's more resistance than otherwise, and areas where it's more reasonable to implement these changes. Utah has, now a proven track record of successful programming around access to justice, and it hasn't, undermined our bar; it's strengthened our bar. So, yes, we expect that if we set a good example and prove in our laboratory, in our sandbox, with data that these things are safe and effective and affordable, that we're going to create a better case for a broader adoption of these types of approaches.
And John, I think you just veered into a topic. Someone just submitted a question online, which is, right, do you see this breaking down any sort of demographic or generational lines, right? Are there areas, even within the industry? I know you guys are taking comment from anybody, right? It's really open to the public where you're taking comment in the sandbox. But have you seen or heard, even anecdotally, I suppose, we can couch that if needed, but have you seen or heard any demographic splits or generational splits where some people are for or against? Is this one of those things where, much like the old lawyer advertising debates from 40 years ago, where the old guard was against it and some of the new guard was for it? Have you seen, or has that manifested itself at all?
I think, it really is anecdotal. So let's be clear about that. We've not gathered data on it, but there does seem to be a divide that the younger generation more supportive, and I think those that have been most concerned have been older and smaller shops, single, sole practitioners, smaller shops, and older. At least, John, that's my sense. What about you?
No, I think that's true. I wouldn't necessarily call it age related. I think people who have a better understanding of how the AI and the technologies may be already play in their practices are more comfortable with this sort of thing than people that are in a more really basic traditional practice. We do have a concern for rural practitioners, but also for rural clients. I mean, that's an area, at least in our state, where the population is distinctly underserved, especially challenged, and yet the lawyers who are out there doing the job are especially concerned about how these changes may affect them. So that's an area where we really do want to focus on helping them understand how this can help, leverage their own practices as opposed to, undermining their business.
The study that we keep referencing that just came out from the Utah Foundation highlighted the justice deserts in Utah, and for those that haven't seen it, it is probably the most profound study of the Utah unmet legal needs market in Utah for those that around the federal poverty guidelines that has ever been done.
But I don't think we should limit the response here to the consumer market. I practice in a large law firm in Utah, and I know of several large law firms in Utah who are really exploring how they may take advantage of these opportunities. I know of other people in large law firms concerned that this means that big four accounting firms are going to come in and, essentially take all their business. And I think there is a question of how people choose to respond to this. The other piece I'd say about that, though, for the private law firms is even big businesses use outside law firms as a last resort in most cases. They will try to do any number of things to avoid engaging their counsel. So if we can create space for even businesses to find a better solution that their law firm can help them provide, I think we're taking a step in the right direction for the entire industry, not just for the consumer industry.
I think that's a really important point, which I think it tends to get looked at a little bit more in the light of the B2C, right, or to the consumer. But looking at it from a business standpoint, right, when people, and I've heard that complaint, that fear too, I should say, which is, the big four accounting firms, this is a play for them to take over the market. And my response is quite simply, they're not lawyers. They have a lot of money. Yes, but they can only buy you if you're willing to sell, and if you're willing to sell, then you have value, right? So this is not a scenario where they can come in and say that we are now the owners of the legal industry. No, quite simply, it's a cash infusion, it's a value statement, but I don't see how it's any different than that.
Well, nor is it a one-way street. I mean, I guess if the right law firm decides to hire accountants or acquire an accounting firm under the proposals we're looking at, that sort of thing is also possible. So, again, you're just loosening the economic environment a bit to try to see what happens.
For sure. And then that's where you get the commingling of professional services, right? Which, again, is about providing that access. I think you'll find people who will walk into an H&R Block or a Jackson Hewitt for their tax returns, but they'll never set foot in a lawyer's office. Right? What if we were able to do both of those?
Yeah, I mean, that's an incredibly important point. And one thing we haven't talked about so far that I think is worth mentioning is we're piloting this, right? This is a sandbox, but it's a 2-year pilot that's being studied by three outside groups to make sure that it's working. And I think that's really important. It's limited. If it works, if the data supports it, great, then we continue it. But it is right now. It's limited to that time period. The National Center for State Courts evaluating it. ILS working with Pew, hopefully evaluating it. Professor Anna Carpenter at the U and a researcher from Wesleyan, Alex Mark, evaluating it. All independent.
And if a firm or an individual wants to give feedback on what is happening, they can go to, I believe it's sandbox.utcourts.gov. Is that correct?
That's right.
Excellent. So what we're going to bring Carson Pearson on right now of Pearson Butler from law firm. They are a law firm in the state of Utah to give his perspective. Carson, thank you for joining us.
Thank you for having me.
Absolutely. Can you give us your perspective on this and maybe what had your interest? Because I know this has been something that has resonated with you.
Very much so. We've been tracking this for quite a while. From our standpoint, we are more of a consumer-based law firm, and we're very excited for the opportunity for innovation and ideas that are coming in. We've already been in contact with tech firms, bank, financial planning firms, and accounting firms, and ideas are just pouring in. So while we don't know how this will entirely play out, we're excited for the opportunity to bring innovation into the legal field. There's been so many ideas over the years that were just non-starters because of some of the barriers that we were operating under, and hopefully this will give a chance to be able to break some of those down and bring more efficient legal services to the consumer.
Can you give us a little bit of your perspective on why it's important for a law firm to think like a business versus a traditional law firm, and how this reform potentially accelerates that?
Well, if you're not thinking like a business, you're not going to be innovative. I think one of the things in our industry that has been a little bit stifling is we operate pretty much under the same rules we've been doing so for decades and decades. And so being able to kind of move into the 21st century with technology, with AI that's coming in, and being able to embrace that will ultimately deliver services to our clients in a better manner. We see so many people that can't afford to get all of the players at the table, so to speak, for their problems, and especially small business owners in the middle class. I know that from the low income side, they certainly need help. but so do the middle class. They can't afford to get all of the counsel that they're looking for. And this will bring an opportunity for multiple disciplines to come together and hopefully be able to provide that more efficiently.
John, may I ask a question of Carson?
Of course.
Carson, one of the things I'm interested in your perspective on is we have rules of professional conduct that include rules about confidentiality and competency and, the substantive value of the independence of the lawyer. And I think people sometimes get concerned that these rule changes are going to undermine that element of what we do as lawyers. How is your firm sort of looking at what you'll do to maintain lawyer independence, confidentiality, all those key elements of the lawyer's service as you look at these options?
So first and foremost, I agree with what Justice Himonas said earlier, and that's the attorneys will still be held to the highest ethical standard, and we don't share a concern we won't be able to do that, whether there's outside players or non-lawyers involved or not. The confidentiality is something we're very interested to see what the sandbox provides in terms of how we're able to house and store our data and who has access to that. And if a non-lawyer or if a partner in a different field can share that access, and whether or not we'll be able to have a client make an informed choice or a waiver on sharing that data, or whether we need to maintain that. Ultimately, the client confidentiality rests with the client. And I think in many instances, they're less concerned about that in consumer-oriented matters than they might be in litigation or higher transactional work.
Thanks.
And Carson, you mentioned something interesting, which is, you're a multidisciplinary law firm, and I think we touched on some of the UK information earlier, and we've got a question that was submitted, which is, do you guys have any insight into those experiments and how it impacts sort of areas of law, areas of practice? Have you seen, or do you have any opinion? Again, anecdotal. I know you don't have the data behind it, but do you have any opinion or feeling as to if this is going to break down that again, a practice area is going to be impacted more or first? Is it just law firms in general, the consumer or business? What do you guys feel about the impact along the practice area stratifications?
I'm not sure I caught your entire question. My audio is breaking up a little bit. Could you repeat it, please?
Sure. I think looking to the UK, there's, with what they've done, and I think the question is now being asked based on some of that data, along with some of these anecdotal data that we're starting to see come in now. I guess, Carson, question for you, because your law firm spans multiple practice areas, but obviously Justice Himonas and John, you can chime in as well. Do you think there's going to be an impact on certain practice areas first or more than other ones?
I think there'll be a tremendously disproportionate impact on practice areas. That'll probably change over time, and as more and more innovation comes into the field. I think that there's a few practice areas like.
Looks like we lost Carson.
That will probably come in quicker. I know that the committee has mentioned things like debt collection, bankruptcy. There's a lot of areas that can be translated easier with form-based practices, and that people, for lack of a better term, fit in the box a lot of times, and that will be easier to deliver services. Programs like the licensed paralegal practitioner rule and the LPP, that can be extremely beneficial, and that could be carried out perhaps maybe even on steroids in the sandbox. I don't know, but the ability to train other individuals underneath the oversight of a competent attorney to be able to deliver legal services and advice, and really for those that fit inside the box, I think could come in much quicker than some of the bigger technological advances I would expect over time. And
you mentioned technology there at the end of your statement, which again, the second question we just got asked, not second, the next one was, we did a lot of talking around access to justice. We touched on some technology areas here. There's no, as far as I understand it, and I'll look to John and Justice Himonas to give a definitive answer, but there's no rationale needed to participate in this, right? It's not like I can only participate if it's furthering access to justice. These rules are out there. I think those are the rationale for why they're being proposed right now. But in order for someone to participate in the sandbox, it's simply just practicing law, right? There's no overarching need that has to be met, whether it's technology or access to justice.
So I would put that a little bit differently. It is true that the sandbox is agnostic at this point, but the drive behind this is access to justice. And you have to recognize that that goes all the way up to the top 1%. So it's not hard to imagine that just about everything that comes in is beneficial to that. What is required is that it benefits the consumer, right? That it's the consumer of legal services is made better off as a result. And I think that necessarily will increase access to justice. It may not increase it necessarily for the poor, although several of the programs we're talking about certainly are operate at the lower socioeconomic element. Right? So it's if you think of access to justice, if you gauge it as a huge problem, as huge as it is, going all the way up the kind of the scale, it's hard to kind of disentangle the program from helping the consumer in some way. But it's not explicit. That's true.
And the reason that I think we considered that, should we sort of, give the nudge towards things that more discreetly address a particular access to justice problem. And the reason we believe that that's really not the right choice is that we want to create the space for the innovation across the board, in part because innovation, at some segment of the market drives the cost down more broadly. And if you had any question about that, ask yourself who first had cell phones and who now has cell phones. Those things evolve, and if we're trying to increase access, we may have to start with something that isn't specifically dealing with the most dire need out there, and then hope that the market responds to the broader population.
Excellent. I guess, Carson, a question that I have for you, and John, practicing attorney yourself, I'm sure you have an opinion on this, which is, I'm sure you guys all have ideas and sort of what you want to do, right? This unlocks potential. This unlocks some ideas that we've all had in the past. Perhaps a softball question or a very open-ended one at the least, but what's the first thing that you're thinking of doing on your own or with your firm should this actually pass?
Sounds like Carson may be having a little trouble. Is it okay if I jump in?
Yeah, go right ahead.
Okay. I mean, our firm already runs a lab, and we do automated dock assembly and stuff like that. But I'll tell you one thing I've had on my list. I don't know that I'll do it. I'm better at the ideas and the implementation. But there are so many guys driving around with contractor trucks. Okay, there are
We're hoping to be able to partner with professional organizations outside of our industry. Very much most interested, and already in conversations with accounting services, with some technology. Justice Himonas mentioned legal apps. And so we're hoping to be on the forefront of that and part of the revolution, if you will, in delivering consumer-based legal services. I also think that there's some bundling potential that can happen here. A lot of industries get together and they bundle services to bring costs down across the board. And I think there's a potential for that. Obviously, we need to be careful and watch out and make sure we're protecting the independence of the legal advice. But there's an opportunity where we're already, as attorneys, counseling on aspects such as insurance or as title or real estate that was mentioned, and being able to perhaps bring additional legal expertise to those tables.
Yeah, I love that bundling idea because that obviously will bring costs down. And John, I guess back to you were saying something about a contractor truck.
Yeah, that's actually the kind of fits with the bundling point that Carson just made. There's all these guys, they don't know how to keep their business license current, how to keep their taxes correct, how to make sure they're doing things with employer withholding, corporate forms, annual meetings, all those basic pieces of operating that business. And then occasionally they like to be able to have a lawyer to talk to the guy about how they haven't got paid on their bill or whatever the thing is that they're dealing with. I think you could build a subscription service for those people, where based on subscription pricing, where for so many dollars a month they would get a package of those types of services, and it might involve some accounting service as well as some legal service. but the point would be you tailor it to that particular type of small business contractor, and probably provide them with a good basic fundamental business service to support their operation, instead of their wife trying to figure out when the W-2s need to be filed or whatever it is.
Right, breaking out those big old payroll charts, the payroll tax charts, and trying to figure that out. Right, if they could simply bundle that, to Carson's point again, or if you could simply bundle that together and get some accounting help along with some legal help. And John, that idea of doing a subscription basis makes it flexible, right? That opens up the access to it. Right. Those are pretty cool ideas.
Yeah, and then you can buy, you buy time. You have kind of unlimited, depending on your level of subscription, John. I guess unlimited questions, or certain limited number of questions or hours, however you want to do it. I mean, you bet.
It raises one of the questions I think that we're struggling with is, how do you deal with conflicts of interest? Because if you wanted to do that for, say, your market was to try to have 200 small contractors like that, each paying you, let's call it $200 a month. That's what is that, 4,000 a month or 40,000 a month? I don't know. But now you've got 200 contractors, and you've got to be sure you're not in a conflict situation between one of those clients and another of them. But those are the kind of things the sandbox is there to try to parse through.
The conflict piece there is interesting. I had not given that a great deal of thought, to be honest. Carson, I'm assuming you got, I know in your regular practice, conflicts are obviously you play a big role in terms of managing, new business intake and how you guys work at the firm. Have you given thought in some of your earlier conversations to how that could impact your decision-making under this new paradigm? To try to parse through the conflict piece there.
So
Carson's a bit delayed there.
But to John's point, right, some of these are things that we can examine and evaluate in the sandbox. So think about the tech piece where, maybe both sides can access the same tech platform, and that tech platform may be able to mediate, as well as provide both sides some legal advice, as well as data, for example, about where cases like this might settle. But if you could establish that the algorithm doesn't share, that there's no possibility that by both sides entering it, they're actually exchanging confidential information. I think that's something that you could establish in the sandbox and get some relaxation of the rules to allow for that kind of product.
So I also think you bring up an important point about the subscription services and budgeting, right? To have a known cost of services, a repeatable cost every month, whether or not you use the service, at least it allows you to know that if a question does come up or concern does come up, that now you have that access. It's almost like an insurance policy, and goes very much along with kind of the whole evolution of all businesses towards a subscription-based model. We are seeing a number of questions come through here. I want to make sure that we get to these for our viewers who are watching us live. This is an interesting one. Someone is asking about law school and the impact of how this will affect lawyers spending large sums of money on law school, and how they will pay loans with the question here is with the real possibility of depressed wages. But I think there's definitely benefits here that if you guys wouldn't mind touching on that, that the door is now opening for those who are coming straight out of law school.
So there's no evidence coming out of the UK that the number of lawyers has reduced. Right. I don't know about the ultimate wages, but that's one of the things that we would certainly be looking at as we study this. But I think this is an opportunity and expand the market for lawyers. If you're bringing in capital, you're bringing in more people that want lawyers, want legal services. I don't see that it reduces it. On the other hand, if there's increased competition that's driving down some of the price, that's good for the consumer. And I take the individual's point about law school, but I think that's a problem we have and that we're looking at, frankly, with the law school model. Right? I mean, it's That's the problem. And I think that goes back to, like, the licensed paralegal, certificating social workers, librarians. Arizona, as I understand it, is now looking, the University of Arizona offers a bachelor's in law. And they're looking at authorizing those individuals to practice in certain limited areas too, right? So what if, instead of having to earn that, pay the 60 grand a year, whatever it is, you could get a certificate and offer certain types of services you can't charge for. You could get a bachelor's or an associate's and be an LPP and offer that. You could get a bachelor's, offer a little bit more. You can get a master's, which the university offers, and offer a little bit more. Or you can be the thoracic surgeon in the law and get your JD and be able to offer the full panoply of services.
Yeah.
The question is really good, but the problem that the question highlights is not with what we're doing. It's with the law school model of just, everybody has to be a thoracic surgeon and we're charging that rate.
Well, I think it's also highlighting a problem with the law firm business model. We know that the efficiency in terms of billable hours of people in your standard law firm is really strikingly low. In other words, lawyers are spending a lot of this well-trained professional time they have doing something other than actually providing legal services. And so, will the person who takes the job staffing the office at Walmart, make the same income as the person in a private law firm somewhere? Maybe not, or maybe the person in Walmart will be a licensed paralegal practitioner, who knows? But I think there is room with different business models for more efficiency in how the lawyers spend their time. And the other piece I'd note there is, if you're the person that dreams up this subscription service for contractors, what you've done is you've leveraged your legal ability and applied it, to a broader range. And I don't know, I don't think that's going to negatively impact your income. I think it could potentially really allow you to leverage your skill set to do that, to do better financially.
Yeah, I think the question around depressed wage is interesting, because a part of me wants to agree that no doubt it'll drive the cost of services down, which to the consumer is great. If you're the one providing services, you could look at it as having a negative impact. The way I would look to mitigate that is, as you guys touched on, which is increased scale. Right now, there's a finite amount of lawyers, and with the cost of legal services as they are, there's only a finite amount of people that can afford those services. So if we do succeed in some fashion of driving the cost of services down, yes, that is another way of saying that we've depressed wages, but you now have the ability to offer more services. You have more scale, and that allows you to have a business that provides those services. Instead of you being the only lawyer that's capable of doing it, you can now say, okay, well, if I need to charge, $500 an hour, $1,000 an hour, and therefore I can only have N number of clients that can afford it. What if my rate drop? I have to make up that income. I can now afford to hire some LPPs and offer at an even lower rate. I now can make it up with increased scale, or I can have a technology platform that offers it that doesn't even need my insight whatsoever. Like you mentioned, John, I'm now leveraging my background into a business where, yes, my frontline wages in true are now less than they were before, but I now have a business that is leaning on that is an income stream. Right. And going to law school, unfortunately, does not, I'll say this as the most recent graduate of law school on this call here, does not provide you the tools or the ability to know how to do any of those things. It simply teaches you, like you said, Justin, to be a thoracic surgeon. When you get out of law school, you are, quite frankly, ill-equipped to really be a lawyer unless you get a job. And if you don't get a job, which I graduated in 2010, was not a great climate for getting a lawyer job. And if you're going to graduate now in the next year or two, it might also be a poor time to get a job as a lawyer. I think you're right. That model has to be addressed, which is, are we equipping lawyers to be successful in the world that we are in today, even if we don't change this stuff?
Yeah, we've and this is really the court's fault across the country. We've created this regulatory structure where you have to be a thoracic surgeon or the legal equivalent of it. That's the example I always use. And we've made no room for the nurse practitioner, physician's assistant. The LPP was an important first step in that progression. This is an additional and bigger step in that progression. Because we have to change that educational model. Like I said before, the comment, what was the economics really underlying that previous comment was the cost of the education itself, not the repayment.
We could talk about the repayment another time.
Yeah, well, but I do agree. But I agree with you, right? I mean, one thing we're trying to talk about a platform, a distribution mechanism that is allowing us to access that enormous untapped legal needs market.
That's correct. That's correct. And there certainly are levers that are pulled on either side, but the focus here is, right, when we have lawyers, a community of them, how can we broaden their reach in the most effective possible way?
Absolutely. It looks like we have Carson back. Let's see. Carson, can you hear us?
I can hear you now. Sorry, the audio cut out.
All right. No, not to worry. I have a question that came in here that obviously is very timely with everybody currently working from home. Does a shift to virtual work and video conferencing accelerate this in any way? And I'm going to add a layer to this question is, had this already been in effect, how would it potentially have impacted the lives that we're currently living working from home? Would there have been any significant impact?
Well, so first of all, I think that the court thankfully has invited, even as we have our rules out for public comment, proposals from anyone who has a particular solution that would meet problems being created by the COVID-19 crisis. So we wish that had been in place, right, to be more responsive. You can see vast numbers of people struggling with vast numbers of things because of COVID-19. And if there is somebody out there that has the right criteria to bring something out to provide service before even our rules are formally approved, the court would like to hear about it and look at that. So in that sense, yes. I think the remote working piece is just kind of underscored for all of us that there are different ways to do things, right? And the way we've done them all along isn't necessarily have to remain the same. And there are pros and cons to everything. And also, we are able to adapt, right? So the courts are doing hearings remotely. Does that mean we should have people who aren't lawyers argue legal motions in court, whether it's remotely or not? Probably not. I mean, I don't think that's the intent here, is to go right to the heart of what, lawyers arguing cases in court. But it shows that there are ways to adapt and manage the downside risk without ultimately destroying the service of what we're doing. So I'm not sure that answers the question fully, John, but that's my reaction to it.
The Chief Justice of Michigan not too long ago was quoted as saying, this isn't a crisis that our industry wanted, but it is the crisis that it needed. I think what we're seeing is courts and law firms and everybody else recognizing and trying to harness a lot of the power of innovation. And that's, ultimately kind of underlies the thinking behind the regulatory sandbox.
If we can touch on one point here, which we have not paid that much attention to, but I think is important. I know we're coming close to the end of our show here, which is fee splitting. That to me actually is the most, I guess, headline worthy comment over here, right? You could take on outside ownership, but that's going to involve finding someone to finance you, right? Or someone willing to get into the business. Fee splitting to me really, on one hand, opens the doors, right? If I'm a lawyer and I don't want to or can't handle a case, I can get someone else, and I can now, perhaps get compensation not on a co-counsel basis, right? I don't have to be tied to the case because I generated. So in theory, we should see more movement of cases between firms, more willingness to share. On the other hand, and this is the first comment I heard from a friend of mine that's an attorney, which is once we open this up, now it devalues the client, right? The client is now a commodity. The client now can go ahead and say, okay, here we have a question coming in around this topic right now. Exactly around the commodity from Peter, which is what's left to protect them from being treated like something that just gets floated from one law firm to the next because everybody can take a piece of them.
John, you want to take it? You want me to?
Well, let's Mutt and Jeff it. That seems to work pretty well. You want to start?
Sure. So, underlying both rules is an obligation that you meet your ethical obligations to that client. And I think that cuts against kind of this notion of you're commoditizing the client. The second is the client gets to make the choice. I mean, there's a little paternalism going on when we say, well, we don't want to do this because, we're going to commoditize them. So we're not going to give them the option. Right. But the fee splitting opens up the ability to have more people or the solicitation, more options for legal help. And you're going to make, as a client, an informed decision, because if you look at the rule, they have to be notified. They have to be aware of what's happening. I mean, I recently went through the purchase of a piece of property, and one of the things that my agent did is they disclose, here are some options. Here are the people that we would get something back if you went to them. I could see their rates, though. I could see the upside, I could see the downside, and I made a decision. I don't need anybody protecting me and telling me, that they were protecting me by not letting me have this service in the past. It worked to my benefit as a consumer, and I very much appreciated it.
I just add on this question. First of all, both 5.4a and 5.4b, which are the structures that we're finding here, make it very clear that no lawyer is being relieved at all from their duty of loyalty, their duty to maintain confidentiality, their duty to be competent. And it is, I think, a fair observation that we need to be very vigilant that anything that's being done because of these new rules does not undermine those core values. Now, I'll tell you, my law firm and its insurance company are going to be very concerned about what we're doing to assure that we are not creating a problem. So I think there is that type of a constraint on what can happen. I don't think if let's say Carson and I work out a deal where, because he doesn't do, certain type of work, oil and gas work or something like that my firm does, but that he's got some clients who happen to come to him with oil and gas work, that I will actually pay him as a lawyer a 10%, commission, so to speak, or 10% of whatever is recovered in fees from that oil and gas client to send that oil and gas client to our firm. Well, isn't that better for the oil and gas, with due disclosure, isn't that better for the oil and gas client than for Carson to try to do the work himself, because otherwise he doesn't really get any benefit over the relationship. So I think to create a situation where those types of fee arrangements can work actually can benefit the ultimate value and quality of the service that goes to the client, so long as these ethical constraints, are continued to be honored.
And I would love, Carson, I'd love to hear your opinion on this as well.
I think he brings a very good point. Right now, it's in our industry, we're not incentivized, or perhaps disincentivized, to share clients with levels of expertise. Hopefully every attorney is taking their obligation to the client seriously and always placing the client in the best position for them. But we know at the end of the day that money talks, and that is a barrier that we've had in terms of jumping through hoops. I think cross-collaboration on law firms and areas of expertise. I'm especially interested in the levels of practitioners we might be able to have inside this sandbox, so they can deliver services not by the thoracic surgeon, but by the different levels from a nurse or a nurse practitioner or physician's assistant, with the oversight of the one that has the expertise. And so I just think there's tremendous opportunity for innovation here.
Absolutely. I think to go further into this with you, that comment on injustice, I think that is very well put as to a reason why this makes a lot of sense for the Bar Association to continue to evaluate. I want to thank Carson Pearson from Pearson Butler in Utah. I'd like to thank co-chairs of the Utah Implementation Task Force on Regulatory Reform, Justice Deno Himonas and Attorney John Lund. Thank you so much for joining us today. Thank you to everyone who is watching at home, and for those of you who are watching the replay. Again, thank you all for joining us here today, and everybody have a great day.
Be well.
Take care.
Thank you.